Okay. All right. Let's get them in.
Good morning.
Good morning. Just waiting until everyone comes in. All right, I am Judge Dunaway's interim staff attorney, and we'll be getting started in just a moment.
Can I mention something to you, Ms. Davis?
Yes,
Mr. Koenig and I emailed Lisa Rast. Is Lisa no longer with Judge Dunaway?
she's still his staff attorney. She's just on maternity leave.
Okay. What happened is the court asked us to submit proposed orders. This happened to Mr. Koenig and I by 5 p.m. yesterday. Each of us did so. Each of us got our proposed orders rejected by the Fulton County Clerk's office. We then emailed them to Ms. Rast. If there's another email address we should submit the proposed orders to, please let me know.
Yes, I will go ahead and put my email address in the chat.
Great. Thank you.
Thank you.
And I'm having some technical difficulties with my camera for some reason. This is the first time this has happened to me. So I'll continue to work on that. You can see my ugly mug there in the picture, but for some reason, it's not showing on the Zoom. So I apologize. I'll keep working on it.
Not a problem.
All
Thank
right,
you.
Thank you.
I've got your email there, Ms. Davis. Thank you. And I'm going to forward this message. So you'll have the proposed orders, or the court will have the proposed orders.
Thank you so much.
Jason and George, I don't
Yes.
plan on saying anything because I don't have a dog in this fight. And matter of fact, if I really did, I would have asked for a leave of absence. My son's getting married this weekend, and I got a lot of stuff to do today.
Oh,
Yeah.
okay. Congratulations.
Yeah,
He's supposed to
congratulations.
get married in March of 2020.
Wow.
Yeah.
So anyway, so I'm just going to sit here. Probably, matter of fact, if the judge wouldn't be upset about it, I'll probably just turn off my video. And since I'm not going to be saying anything, I don't know if the judge cares, or and I'll turn off my mic as well and just sit here.
All right, you can listen. That's fine. Good morning, everybody. I know that we are here for two motions: motion to dismiss and motion to add a party. I'm familiar with the facts, as we did have the temporary injunctive hearing. I went back and reviewed the complaint, and of course, I've read the motion to dismiss and respond. So I do have my notes in front of me. The motion to dismiss, I understand that the defense, C Global, wants to dismiss count 1, breach of contract, count 2, quantum merit, count 3, unjust enrichment. The plaintiff kind of, I don't know if they agree that it's moot or that it's not an issue, but that promissory estoppel is probably no longer in the case, that there are no counts against C Global for tortious interference with the contract or business relation, so that therefore there's no punitive damages against C Global. That's kind of my quick rundown of where we are. And so I guess I'll hear from the plaintiff. Am I correct that promissory estoppel, tortious interference, business relation, contract, and punitive damages are no longer in the case?
Close, Your Honor.
Okay.
With respect to the promissory estoppel claim, we do allege in the complaint that promises were made and that we relied on those promises. We don't consider that moot. And I just quickly, as Your Honor was speaking, looked over our response. We do consider the specific performance and the injunction to be moot for the reason that the exhibit is already being held at Underground Atlanta. I mean, there's no purpose at this time because the exhibit will not be held at our facility for us to continue to seek specific performance and interlocutory and permanent injunction. Of course, they were appropriate at the time. We feel they were appropriate at the time, but at this time they are moot. That is count 7 and count 8.
Okay. But with the promissory estoppel, there's still a claim for promissory estoppel, I guess some other damages other than specific performance.
Yes, promissory estoppel. That's right. Yes, Your Honor.
Okay.
Unjust enrichment, quantum merit, breach of contract. Breach of contract. We intend to continue to pursue those claims.
Okay. What about the punitive damages claims against C Global?
Yeah, we don't have a tort claim now. They base in contract this time, so we agree with that as set forth in our brief.
Okay, very well. All right. So I am ready to take up the motion to dismiss. So I'll hear from C Global.
Yes, Your Honor, first off, good morning. This is
Good
George
morning.
Koenig. I apologize. For some reason, I'm having technical difficulties with my camera. And so I apologize. You have to see that picture of me smiling the whole time that we're talking. But thank you for taking the time to hear our motion on this. What I'd like to do is sort of walk through our concern, our issue, and why we think it's unfair for us to try to do discovery or continue with where things stand at the moment. Just as you went through, I was going to say at the beginning what counts remain. The key counts that we're talking about now are 1, 2, 3, and 4. And then count 9 would be a claim for attorney's fees flowing from that. Count 1 is the breach of contract claim. Count 2 is the quantum merit. Count 3 is unjust enrichment. And then count 4 is promissory estoppel. Those first 4 all flow from basically the same concern we have, and that is we don't know what the promises were. We don't know what the essential terms were. And we think that as a matter of fair pleading, that we should be entitled to have that information because it's going to affect whatever we do in this case going forward. In our brief, we've laid out basically the 4 necessary factual frameworks for a contract. There are 4, only 2 of which we think are an issue with the way the complaint is pled. The first issue is parties able to contract. That's not an issue here. We would agree that both parties are able to contract. The second one would be consideration moving to the contract, which we do have an issue with. The third would be the assent of the parties to the term of the contract. We have an issue with that as well. In fact, that's the heart of our concern. And then the last one would be subject matter upon which the contract can operate. Essentially, we know this deals with the Banksy exhibit, so that's not an issue. But the question really is on these 2 issues of consideration and terms. When it comes to consideration, the question is, where in the contract or in the complaint are they telling us what they did and how that flowed to the contract? Now, I'm new to the case. I was not at the injunction hearing. But to give an example of what would be clearly consideration flowing to a potential contract, there was some discussion, I understand, in the injunction hearing about a $50,000 production fee that was not paid. That would be an example that if the plaintiff in this case had done that, that would show consideration flowing to the contract. Did they sign a agreement, a document that shows what consideration was flowing? Based on what we've seen in the complaint, there is no contract that was ever signed that shows what the consideration was. So that's the first concern we have, Your Honor. And then the next one is the terms, which I'd like to spend the most time on, and why that would be important as well. You know, the terms, an essential term or term in a contract that matters is one that might affect the judgment of a party whether to enter into the agreement or not to enter into the agreement. And so it's the key what, where, who, when, why, how questions that you see in a typical business contract dispute. The most important would be the financial terms. What did the parties agree to concerning this alleged contract? There is no description whatsoever there in the complaint about what that is. And that's really the rub, is that's something we should know at this stage. What did they agree to concerning the financial aspects? Another essential term that you typically see in a complaint involving a contract dispute would be a liability that a party took on or assumed. This is not an academic exercise. That really would have happened in this circumstance. There would have been some understanding between the parties as to who was responsible for what, who would be paying for insurance, what costs would be associated with going forward with the exhibition, who would be doing what. And there's really no mention at all in the contract there. What other mutual obligations would the parties have? What would they be responsible for doing so that we would know who did what and whether we did it or didn't do it? That's typically what you see in a business contract dispute and in a complaint. Another example would be what would be the term of the agreement? How long was the agreement in effect? And then when was it entered into? We have sort of a vague reference to sometime in July. And then the question would be, when would the contract terminate? None of those basic terms are alleged in the complaint, and they're critical to moving forward as far as what sort of discovery we would need to do. Having some of that information may impact whether we need third-party discovery, if we need certain witnesses. None of that is clear at all in the complaint. And we believe that that's a failure of proper pleading. And so that's why we've raised the issue. The same issues apply also to the other quasi-contractual claims, the implied contract, the unjust enrichment, and the promissory estoppel. So a lot of the same logic flows, Your Honor, from the issue regarding the lack of essential terms in the contract. Now, you can't base your decision on this motion to dismiss because you have to look simply at the allegations in the complaint. But part of the reason why this is such a real concern that they haven't brought it up is you can see how we've laid out in our counterclaim what the actual facts are, what was being discussed, what was put in documents, what wasn't agreed to by the parties, and why there is no agreement, why there was no contract. So again, it's not an academic exercise. It's a very real core issue in what the parties would be dealing with in discovery. I think we're entitled to know what they are claiming are the material terms of this agreement at this stage, not 6 months later. To quote the good book, if you have a lantern, you don't hide it under a bushel. At this point, if there was such an important agreement between the parties, we should know what that agreement was and what the terms of that agreement are. And I can't tell what that is from reading the contract. So that's why we've raised this issue with you, Your Honor. I can talk about the other issue with adding the party, but I'll stop now in case you have questions for me about the arguments I've made concerning the motion to dismiss.
I guess and I'm going to hear from the plaintiff, of course, but on the I guess the quantum merit argument and the unjust enrichment, the selling of the tickets with Westside's name on the tickets, and I can see Westside saying that some of those tickets sold because our name was on them. Therefore, C Global received a benefit because they used our name. Would that not be sufficient to state a claim?
Our position, Your Honor, would be that that is not the case. In fact, the way it's alleged in the complaint is that Fever was doing this work. It wasn't something that we did or directed them to do. Fever, who is no longer a party in this case, and they were the primary people that were doing the ticketing. And I think we've stated this in our motion to dismiss. Most of what is complained about in the complaint is things that Fever was out selling tickets and putting information on there. Now, again, because I don't want to go outside the allegations in the motion to dismiss, as a practical matter, though, what sold this is Banksy. The location, it was not something that was essential to the selling of the tickets. It was the end product itself and what Fever was doing, because Fever was the one that was really helping marketing it. But again, that's outside the motion to dismiss, and I don't think would be helpful to Your Honor for purposes of making your decision. But we don't think that the basic idea of an unjust enrichment is that you did something, not that Fever did something, not that Fever put something on a document or on a ticket, but that you, the plaintiff, did something and we were enriched by that. And simply putting your name on a ticket, it did not enrich us. And I think it's going to be really hard to come in with evidence on how that somehow impacted what was sold through these tickets. And I understand from my client that it is very common for tickets to change. In fact, what happens is when you change the ticket, Your Honor, you then give the person the opportunity to get a refund. If you don't want to go to it because it's no longer at the Westside Cultural Arts Center, you now get to say, I want my money back.
Okay, understood. All right, from the plaintiff on the motion to dismiss, response?
Sorry, I was on mute. Thank you, Your Honor. We consider this to be a waste of judicial resources. We consider this to be frivolous. Mr. Koenig, with all due respect, is talking about ticket sales and what can happen and all that sort of thing. And as he appropriately pointed out, the courts merely directed to look at the four corners of the complaint itself. We filed a 77-paragraph complaint. It is my contention it could have been a 10-paragraph complaint with much less detail than we provided, because all we need to do on the contract claim, for example, is allege that there was a contract and a breach of that contract and that we suffered damages. As we stated in our brief, this, Your Honor, can only grant this motion to dismiss if the allegations of the complaint disclose with certainty that the plaintiff would not be entitled to any relief under any state of provable facts asserted in support thereof, and that the movement C Global establishes that the plaintiff could not possibly introduce evidence within the framework of the complaint sufficient to warrant a grant of the relief sought. We cite that as the Weather versus DNMAR Music. I'm probably pronouncing that incorrectly. And the complaint is to be construed most favorably to the plaintiff, and all doubts regarding the complaint should be resolved in the plaintiff's favor. We have notice pleading in Georgia. Your Honor, I have litigated hundreds of cases, and I honestly can't remember the last time I filed a motion to dismiss. The reason for that is we have notice pleading in Georgia. The pleading requirements are very liberal. The interpretation of complaints is very liberal. We cited a case, the Campbell case in our brief, where that says that under Georgia law, it is not necessary for a complaint to set forth all the elements of a cause of action. And that's what Mr. Koenig is alleging we have to do in order to survive a motion to dismiss for failure to state a claim. Rather, continuing the quote, the Georgia Civil Practice Act requires only notice pleading, and under the act, pleadings are to be construed liberally and reasonably to achieve substantial justice consistent with the statutory requirements of the act. And I'll wrap up with a final quote, Your Honor. It says, it's from the depository trust case. It says the objective of the Civil Practice Act is to avoid technicalities and to require only a short and plain statement of the claim that will give the defendant fair notice of what the claim is and a general indication of the type of litigation involved. And then the court says, and the court emphasizes this in the opinion, the italics, the discovery process bears the burden of filling in the details. So, Your Honor, we have met the burden under the Civil Practice Act and under the guidelines to give to the defendant a general indication. At a minimum, we think it was much more than that, but at a minimum, a general indication of the type of litigation involved. And we ask that the motion to dismiss be denied.
Okay, let me ask you about the quantum merit. What and I guess what and where in the complaint is the service that Westside performed?
Well, Your Honor, in the complaint, we talk about, and I've got it in front of me. Let me find the appropriate paragraph. We say that Westside, in paragraph 18, reserved the entire venue, foregoing numerous other opportunities. We say that they expended somewhere, I'm looking for it, 28, Westside spent countless hours of work preparing to host the exhibit, has incurred substantial out-of-pocket expenses. And so what Westside did, Your Honor, is we provided, and of course it has to do with the, as Your Honor earlier pointed out, has to do with the advertisement of the tickets to be held at our facility. C Global reaps the benefit of that when the tickets are sold. They get a large portion of the ticket split for all the tickets that were sold there. So what we did is we performed these services, helped plan things, etc., and allowed our name to be used on the tickets. We think that there is certainly a state of, we could possibly introduce evidence within the framework of the complaint sufficient to warrant a grant of the relief sought. And that's what we're going to determine during discovery, Your Honor.
Paragraph 28, okay. Spent countless hours working, performing to host the exhibit and incurred substantial out-of-pocket costs. Okay. And lastly, I think in the motion that the defense filed, they allege, their contention is there were no promises alleged in the complaint. Where in the complaint do I find the promises alleged?
Yeah,
Promissory estoppel.
Yes, Your Honor. We also addressed that in our responsive brief. I'm flipping through. Paragraph 47 says that defendant made certain promises to Westside regarding the fact that the exhibit would be held at Westside. And based on those promises, paragraph 48, Westside expended substantial out-of-pocket funds and did not permit any other benefits, other events to be booked for the time period. And C knew that we were relying on those promises by C. Okay. Those three paragraphs in and of themselves are sufficient under the Georgia Civil Practice Act because it gives notice of our allegations that promises were made. And we'll, hopefully establish via the discovery process that occurred. But that certainly passes muster under the minimal standards for pleading in the state of Georgia.
I see it. All right. Thank you. Anything else?
Yes, Your Honor, briefly. One thing that I would draw your attention to is that there is not some unfettered ability to fail to meet the pleading standards. We rely on a motion to dismiss case, the Weathers case in our brief, and it's a case that involves a contractual claim where the plaintiff failed to properly plead the complaint. And so it is not something that we're relying on authority in a similar circumstance. And the key issue, Your Honor, is even sitting here today, we don't know what allegations were made that show that there was an assent by the parties to the agreement. We don't know, what are they? What are the essential terms of the agreement? This idea that you can just say that it happened, especially because, as I said earlier, Your Honor, this is not an academic exercise. We know that the allegations in the complaint are false because we know what actually happened, because we have attached to our verified counterclaim that there were documents going back and forth where the essential terms were written out, spelled out, and what happened and what didn't happen. And it's very clear that the essential terms were not agreed to. So that's part of why at this stage, it makes sense, knowing the reality, to ask for that to be put in the complaint. What are the essential terms that you say were agreed to? When were they agreed to? And I think we're entitled to that under notice pleading. And I think that is fair notice to a party. Right now, I have no idea what the agreement is, none. Just that it had something to do with using their facility. I don't know what the financial terms were. I don't know what was supposed to be done when. And that I would submit to Your Honor is not proper pleading under the Civil Practice Act.
All right, let's move on to the motion to add a party.
All right, Your Honor, would you like me to speak first on that?
Yes, I was trying to find it. I know I have it pulled up here. Answer counterclaim.
Let me know when you're ready, Your Honor.
I have it. I'm ready.
Okay,
Yes,
thank you
sir.
kindly. All right. So this dovetails nicely into what we were talking about on the motion to dismiss, and that is that we have provided and submitted a verified counterclaim into which we lay out the parties' interactions, what happened and what didn't happen. And in that counterclaim, we lay out the fact that there was a memorandum of understanding that was submitted to Dr. Chappius May 14th. And that we reached out several times asking about what was going to happen with this, heard nothing, never got heard back from him. And then at the 11:59 p.m., the latest possible time, when we had this $50,000 production fee, which you heard about during the injunction, all of a sudden, we got a new document that revised all of the terms. And we were told, this is it, take it. If you don't sign this with the new terms, then, then we're not paying the $50,000 production fee. And my understanding, I do not have the transcript, but what's been relayed to me is that this came up during the injunction hearing and that $50,000 was never paid. It's our contention that this was a negotiating tactic from day one, that we were misled, that we were told that they were going to sign the MOU. In fact, we have evidence to show that it was going to be signed on May 19th, I believe. And that as a result of that, we continued to work in good faith with them, in good faith. And at the last second, they tried to change the deal, and they did so intentionally. And we were intentionally misled. These were all negotiations involving Dr. Chappius. They flow from the same transaction occurrence. They're at the heart of the allegations in the complaint. And so what we've done is we've asked the court to be able to add Dr. Chappius so that for efficiency purposes, to save time, we can have this all in one proceeding and get this all fleshed out and done with, because Dr. Chappius was central to the negotiations. He was the negotiator for purposes of the plaintiff. So that's the purpose of ours. We believe you have the authority to do that. And we would ask that you grant our motion to add so that we can move forward with, discovery on both issues, the counterclaim that involves Dr. Chappius and the claims that are made by the plaintiff.
All right, very well. I'll hear from the plaintiff on the motion to add party.
Your Honor, throughout this morning's hearing, Mr. Koenig, on behalf of his client, has made numerous conclusory and factual statements that we clearly dispute and disagree with. But I'm not going to engage in those unless Your Honor wants me to, because that's not the standard for anything the court is deciding today. We certainly will be able to produce a document supporting the contract and dispute many of the alleged facts and allegations that Mr. Koenig's made today. In any event, with respect to, and we feel that the attempt to add Dr. Chappius personally in this case, we know it's a fundamental tenet of law that an LLC and one or more of its members are separate entities. The attempt to add Dr. Chappius is an attempt to exhibit or exert undue and inappropriate pressure on an individual that has no potential liability in this case. In any event, the standard is this, as we set forth in our brief, 91113H and 91119A say that Your Honor is only has authority to add a counterclaim defendant when the presence of that party is required for the granting of complete relief. It's not if it's desirable. It's not if it's more efficient. And we cite the McCabe versus Lundell case saying that the statutes do not authorize the addition of a defendant in counterclaim merely because it may be desirable. Why is Dr. Chappius, his presence in this case, not required for the granting of complete relief? Well, it's because he, as alleged by the plaintiff, alleged by the defendant in the counterclaim, he is a joint tortfeasor with plaintiff. That's what they allege. And the case law is clear, as set forth in the McCabe case, that it is not required, and that's what it's got to be, that's the standard. It is not required that all joint tortfeasors be joined together in an action against one, their liability being joint and several. 91119A says that a person shall be joined only if in his absence complete relief cannot be afforded. Permitting the validity of the allegations in the counterclaim, complete relief could be afforded. He is not required under any case or standard, and we also cited to the court Cheney versus Harrison and Lynham, LLC 308, Georgia Appeals 808. Your Honor, in that case, it's almost identical to this one. There was an LLC. Someone attempted to add a member of the LLC who they alleged was a joint tortfeasor, and the court said, you cannot do that because the joint tortfeasor is not required for the granting of complete relief. So we ask that based upon our brief and the citations that I've mentioned today, that the motion to add defendant, Dr. Chappius, be denied.
All right, thank you. Mr. Cohen, anything else on your motion to add parties?
Yes, sir. Just briefly, for all intents and purposes, while it may not be required as a practical matter, Dr. Chappius did all of the negotiation. And I'm not just making argument or making up facts for purposes of our discussion today. I have a verified counterclaim that says these things actually happened. But Dr. Chappius interjected himself into this. He did the negotiation. He is the one that has misled my client and strung us out to the last second. If what is being suggested by plaintiff's counsel is that I go and file a separate suit, where we're going to be is then I'll be shortly filing a motion to consolidate since it arises out of the same transaction and occurrence. So we're not dealing with a situation where we got three partners for an LLC and one might have done something wrong. We're dealing with the plaintiff, which is Dr. Chappius's entity, his company. And so it makes sense from an efficiency perspective and from getting complete relief here in order also to have discovery that is economical and makes sense for it to be in this case. And we would ask the court to do that.
All right, thank you, parties. I understand you all got you all now have Ms. Davis's email address for the proposed orders. So if we can get those, that'll be great, and we will get a ruling out at the beginning of next week.
Do you want us
Great.
to send, Your Honor, in a Word version or a PDF version, which is best?
A Word would be great.
Okay, that's what we'll
Yep,
do.
Word would be great. Yeah.
Okay.
Ms. Davis, thank you for providing your email this morning. I emailed you what we submitted to the clerk, which was, of course, was in PDF format, but I will send Word as well.
Thank you so much.
All right, you all have a good weekend. Thank you.
Thank you, Your
Thank you,
Honor.
Judge.
Take care. Bye-bye.